Everyone. I'm Jessica Fisher-Greene. Thank you for joining us. So today we're going to talk about the essentials of estate planning. Some of these terms you may have heard of before, and some of them might be new. We are also going to talk about some changes that have occurred in the last few years in the laws that relate to these documents. So let's dive right in. So starting with the last will and testament, I would say that most people have heard of this document. Probably a lot of you have this document yourself, or at least hopefully most of you. This is a document that if you are at least age 18, so age of majority in Pennsylvania, and you have capacity, so you have sound mind, the ability to understand what you are creating, you can make a will. So if you do not have that level of understanding that is needed, then you are not able to create this document. You know, the question often comes up, who determines capacity? I have a lot of people who will come in and say, well, this person has a diagnosis of dementia. Does that automatically mean that they cannot make these documents? No, that does not automatically mean that just because you have a certain diagnosis. It's actually up to the attorney who has created and is having the documents executed whether or not you have capacity to create the documents. I know in my practice, I have a worksheet that I ask everyone a series of questions to make sure that they completely understand the documents that they're signing that day. So why should you create a will? First off, it's a great way to let everyone know who you want to receive your property after you pass away. And it can let you know how you want them to receive it. So if there are any parameters around it, if you do not want them to get it outright for some reason, you can be as creative as you want with it. You can also use this document to choose who would be in charge of settling your estate. So that person would then take on all the responsibilities of following your wishes in your will. And you can use it to appoint someone to be in charge of any minor children that you may have, so guardian for them, or even a trustee for funds for a minor beneficiary or someone who may have a disability. So you can create a trust through your last will and testament, and this is called a testamentary trust. It is usually only for a specific purpose, and it only becomes effective or created after you pass away. And then at that point, it is irrevocable because you cannot change your will at that time. Some standard ones that we typically see would be an underage trust. So let's say that you're leaving assets to an individual who maybe they're under age 25 and you don't want them to get the money outright. So it would be held in trust until they're 25, but could be used for education, health, maintenance, support, whatever they might need before that age. It's just that they cannot walk into the bank and clean it all out on something silly. Trusts are also really helpful if we're worried about like a Medicaid nursing home situation. We would not to a spouse who's in the nursing home. So we use spousal trusts and supplemental needs trusts to accommodate that. Supplemental needs trusts are also helpful if you have someone who you're leaving something to, not necessarily a spouse, but someone who is receiving, some sort of government benefit, whether it's Medicaid or SSI, a benefit that would be disrupted if the person received assets directly. So the supplemental needs trust prevents the loss of their benefits. A spendthrift trust is very helpful if you're leaving assets to someone who you're worried about their spending habits, that you think they would blow it all in a month. We can set up those types of trusts. They're not necessarily based off of age, but more based off of the discretion of the person in charge of when and how to make distributions. We typically say that you want to update your will and really all of the documents that we talk about, update or review them upon the 4Ds. So if there's a divorce, whether it's your divorce or one of your beneficiaries or trustees, you really want to look at this. If there is a death in the family or amongst your friends, again, someone who you've named in the document at all, we'd want to revisit. If anyone has received a new diagnosis, long-term illness, again, we'd want to look at it, and then every 10 years. So we'll talk a little bit about probate and the last will and testament and how they go together. I get a lot of people who come in and say, I'm going to do a will and then I'll avoid probate. That's not exactly how it works. So the executor, the executrix, personal representative, that is the person that you have nominated in your will to be in charge. If you do not have a will, then that person is called the administrator or administratrix, and that person is chosen based off of Pennsylvania law. Now, creating the authority for that person to truly be in charge is not done just by naming them in the will, but in fact, you have to file the will at the courthouse with the Register of Wills. And then when they declare that the will is valid and they admit the will in, that is the probate process. So they go hand in hand, but just because you have a will, people are not going to follow that without the Register of Wills saying that the will is valid. Now, a little bit tricky here, though, the will only controls probate property. Probate property is property or an asset that an individual owns in their name alone that does not have a beneficiary on it. So after someone passes away, like I said, we have to admit the will into probate. So first you're going to be either the executor or attorney will be completing a petition for probate. Each county has sometimes a little bit of a different thing that they want on that petition. And then the executor is sworn in. So they actually take an oath that they're going to pay any and all taxes and follow the will and do everything that they're supposed to do. In some cases, especially where there is not a will, then the executor has to post a bond, which is basically like an insurance policy for the beneficiaries that the executor is not going to skip town with all the money. And then once you've opened that probate process, it starts a timeline. So they have to send notices to heirs within the first 90 days of opening probate. And they have to pay the inheritance tax, which is due 9 months from the date of the person's passing. Now, if they prepay the taxes within 3 months of the passing, they'll get a discount on it. So let's talk a little bit about Pennsylvania inheritance tax. So this is not the same as the federal estate tax. The federal estate tax, they have an exemption. So that means that if your estate is worth less than that exempt amount, you do not owe any federal estate tax. Right now for 2026, the federal estate tax exemption is $15 million for an individual and double that for a couple. So most people are going to avoid that federal estate tax. However, in Pennsylvania, it is not based off of the amount you're leaving behind, but it is based off of the relationship of the person who's inheriting. So as you can see here, and this was something that's been updated in the last few years, it is 0% for transfers between spouses, But now they have added any transfers between a child and a parent where the child is age 21 or younger. And they've also added any serving military members. So if they died from an injury or illness while active duty, then there would not be any inheritance tax to their heirs. And then it goes up from there. So any sort of direct descendants, children over 21, grandchildren, parents, grandparents, they're at 4.5%. It's 12% to siblings, and then pretty much 15% to everybody else, except charitable organizations do fall into that 0% category. So if you're somebody who's been living with your significant other for a very long time, in your mind, you're married, if it was after 2005, Pennsylvania is not going to honor you as spouses, and you'll be hit with the 15% inheritance tax. So here's another good one. I have people come in all the time and think that if they avoid probate, they're going to avoid the Pennsylvania inheritance tax, which is not true. The only asset that's going to avoid the inheritance tax would be life insurance. Anything else that's in that person's name, even if it's jointly owned or they have a beneficiary on it, they're still going to have the inheritance tax. And you hear people adding like POD, so it's pay on death, or transfer on death. You're still going to have the inheritance tax on those types of assets. So some things to be aware of, when we're trying to avoid probate. So sometimes people will say, well, I'm going to make my child a joint owner on my property. Okay. So if your child passed away before you, you would actually then have to pay inheritance tax on your own money. If your child, again, is a joint owner with you, their share could be subject to any of their creditors, or if they're getting a divorce, there could be issues there. And another big one is that, let's say you have 3 children and your will says that you want to split everything 3 ways, but this joint account has just one child as a joint owner. That child gets that whole account and they do not have to split it with their siblings. So this can create a lot of issues when you were hoping that they would actually all get it equally. Moving on to the durable financial power of attorney, we like to argue that this is actually, the most important document for someone to have. It allows you to choose an agent, person to be in charge, to handle your finances and your legal affairs. So who should serve in this role? Has to be someone who you trust, someone who's responsive, who's able to pay bills and, not easily get overwhelmed. And if you have a will or a trust, you still need one of these, because the will only comes into play after you pass away. The financial power of attorney only works while you are alive. So they're working at different times. And even if you are married, your spouse does not have the automatic right to make decisions for you. You do still need to have this document appointing your spouse to help make decisions and pay bills and do those things for you. So what does it control? It's going to control things with your name on it. So any assets and income that are coming in, this allows your agent to talk to those groups for you. It also is going to control any legal decisions. So, if you have to be admitted to a nursing home or, sign some other contract, or if you own a business, your power of attorney will act for you. If you do not have one of these and you become incapacitated, now we're left with Pennsylvania law, which would be where we would have to petition a court in guardianship, which is a very expensive, stressful, and time-consuming process where a judge would declare you as incapacitated and then appoint whoever the judge thought should be the person to handle your affairs, which might not have been the person you would have chosen. So it's so much better if you have already chosen this person and made these decisions while you were able to. And then same as the will and the medical directive, you want to update this among the 4Ds. So like I said, any big changes that come up, and at least every 10 years, take a look at this document. So there were some major changes in the law in 2015 and 2016, which basically made it so that you have to be really specific in these documents. It used to be that you could have a power of attorney that was just 1 or 2 pages long. It was the longest run-on sentence you ever saw, but it just kind of put everything in there and then said, and anything else I do, my agent can do too. But now they want you to actually specify what your agent can do, especially for the ones I have listed here. So if you want your agent to be able to make a gift on your behalf, and this is not just a gift to a family member for a birthday. This is really important when it comes to Medicaid planning, nursing home asset protection planning. Your power of attorney has to have specific language about gifting in order for your agent to protect any assets. We also want to see the ability to deal with jointly owned accounts, so creating or changing rights of survivorship and dealing with beneficiary designations as well. If your power of attorney does not list these, it really ties your hands when your agent is trying to do things for you, like I said, with asset protection. Then in 2020, there were some specific provisions added that had to do with online accounts, electronic communications, digital assets. You want to make sure that your documents reference that your agent can access those accounts for you, especially in this, digital age that we are in. It makes it a lot easier so that your power of attorney can access these items. And even if you have like an iCloud photo or something with your iPhone, these are all things that would need to be covered under this. So switching gears to medical. So the healthcare power of attorney is different from the power of attorney I just mentioned because this power of attorney controls healthcare decisions. You are still naming an agent, so a person to be in charge, but now they are making healthcare decisions and only when you are unable to make them yourself. We also have a waiver of HIPAA, so I'm sure everyone's familiar with HIPAA by now, that it's that privacy law for your medical records. This allows your agent to see your medical records to help you make an informed medical decision. So I do have some examples of powers that your healthcare power of attorney agent would have. And it's really everything that you can think of if something would happen that you need someone else to authorize these types of procedures or decisions. So, as you can see, authorizing or withdrawing or withholding any sort of medical or surgical procedures, dealing with tube feedings, authorizing or withdrawing, your admission or discharge from somewhere, hiring and firing people to take care of you, taking legal action to follow your wishes. They can request a do not resuscitate order, and they can authorize or refuse any sort of organ donation. So in this document, you are able to provide guidance and goals for your agent for how they should act if you are at the end stage of a medical condition or have some other extreme irreversible medical condition. I have some examples there. A lot of people will write in, keep me comfortable. That's a goal. Hospice when needed. You can also now, I've seen a real shift that people are writing in how they want their body handled after they pass away. So you can write in a preference for cremation, or if you want a full burial. I do recommend that you prepay that and make all those arrangements ahead of time so we don't have to worry about it after. It makes it so much easier. In this document, then you can also address if you have severe brain damage and then say your heart stops. How do you want to be treated? Do you want them to give you CPR? Do you want them to get your heart going again? Or do you want them just to kind of keep you comfortable? So now we're going to shift a little bit into the living will. So technically, the living will and the healthcare power of attorney are two separate documents, but we do combine them into one form because that's the Pennsylvania form that is put out there as a recommendation, and it just makes it a lot simpler. So you have all the medical in one, and you have your financial power of attorney in the other. So in the living will, though, you are providing specific directions for an end stage medical condition. So you are not going to get better. You know, you have this medical condition, you're in the final stage. So, like the final stage of cancer, for example. Or you are permanently unconscious. So we know you're not going to wake up. You know, the doctors have decided this, there's no brain activity, all of that. So in here, then you can direct how you want treatment to be handled. The default is that you want to make sure that it's set up so you're not in any pain and to make sure that you're just kept comfortable. And it does also get into if you would want life prolonging procedures. So it's already kind of defaulted to say that you do not want anything to prolong your life if you are at the end stage or if you are permanently unconscious. But if you did want some of them, then you would have to specifically state, I do want them. So some of those items that you could specifically say that you wanted would be like if you wanted CPR or antibiotics. These are things that you could write, I do want in the form. You can also address whether or not you would want tube feedings or hydration. And then you can say how you want your agent to follow these instructions. Should they follow them exactly how you've written them here? Or do you want them to use them as a guide, but they have final say and can override what you have written? There is a legal protection clause that's in there, and it just basically says that as long as your agent and the health providers are, acting in good good faith, then they are going to be protected from liability. So there were some updates to this one as well. It overcame kind of an interesting conflict in the old documents. So, in the old documents, you were saying, I want to be an organ donor. But on the next page, you're saying, don't put me on any machines ever. But, we have found that you might need to be put on a machine temporarily in order to facilitate that organ donation. So now the new document has a section where you can say, I don't want to be on machines, but if it is for the purpose of organ donation, then I'm okay with it for a temporary period. Or if you're not wanting to donate, you would just say, don't ever put me on any machines. So it's like a two option scenario there. It also really separated out what it means to be an organ donor. So it used to be that organ donation was just one, umbrella term and everything was covered under it. But now there is a separation between traditional organs and tissues, and that's kind of like the default organ donor designation. If you have that on your license, that's what that means. But if you wanted to give your hands, facial tissue, limbs and other vascularized composite allografts, then you would have to specify that in the document. So we're going to switch gears here to living trust. Earlier, if you recall, I explained a testamentary trust. So that is a trust that's created through the last will and testament, and only after you pass away is it actually going to become effective. The living trust, though, is a document that you create while you are alive, and it really takes on almost like its own kind of like person. Like it's a new person that you've created that now they're going to own your assets. They're going to take title to what you had previously. So this can be revocable or irrevocable. It just depends on which way you're going. But the key thing to remember is it's one that's created while you are alive. And for it to actually work, for it to actually be followed, you do have to transfer the ownership from your name to the trustee of the trust. And then once that happens, the trust document is going to say how it is all controlled while you are alive, and even then when you pass away. It's going to have, specific directions for how things should be managed. So who could serve as trustee? So this is our person in charge of the trust. So again, anybody who's at least 18 or older, and they have to have that capacity. So just like a will. And same thing for creating a trust. If you want to be the creator of the trust, you have to be at least 18 and have that sound mind, have that capacity. Now, for a revocable trust, you could serve as trustee. So you could be the person in charge. But if it's an irrevocable trust, I do not recommend you being the trustee of that. And like I said, it could be any adult as long as they're of age and they're competent to handle this for you. You can also look to organizations like a bank or a trust company. And I have some corporate fiduciary rates there for you, but generally 1% to 1.25% would be a reasonable rate. So what is the trustee doing? Similar to power of attorney, they're managing your assets, they're paying your bills, they're receiving the assets, they're investing them, they're handling things with the banking. If there's a house in there, they're taking care of things for the house. So the trustee really kind of takes over all those things once the ownership has changed. So looking at the revocable trust, you can revoke it. You can change it. You can add or remove assets at any time, change the beneficiaries, get rid of the thing altogether, completely up to you. The irrevocable trust, though, is a bit trickier, and you really can't change it once you have it. If you wanted to change it, you would have to get approval of everybody involved in the trust. So all the trustees, the beneficiaries, everyone would have to sign off. So, why create one of these? In the living trust, some people think of it as like a will substitute. So you can name, who you want to inherit, who you want to benefit from this, provide specific language for them. So as I mentioned earlier with the testamentary trust, if you have someone who's going to receive property from you, but they have a specific need or a specific concern, a living trust might be a better way to handle it. It just depends on the situation. So if we're worried about that person getting a divorce, or if they have any sort of dependency concerns or creditors, or they're receiving government benefits, these are all reasons why this type of trust might be helpful. And it's going to lay out, when they receive the property, how they receive it, who's in charge of it, and it will avoid probate. So this can be really helpful, especially if you own property like real estate in more than one state. You may want to consider this because it might be a pain to open probate in both states. Here in Pennsylvania, probate is not that bad. So we're not typically saying, create one of these trusts just to avoid probate. Usually there's kind of a better reason for it. Some people like the privacy of the living trust, and they don't like that when you have a regular will, anybody can go into the courthouse and look at it. Now, these trusts used to be really popular to avoid the federal estate tax, but like I said, right now that it's so high, the exemption, that's not as much of a concern. So looking at the irrevocable trust, though, it could help with avoiding the Pennsylvania inheritance tax. So look at the various tax rates for the beneficiaries that you want to leave something to see if it makes sense to do that. It can also accelerate someone's eligibility for veterans benefits. So the pension in specific has income and asset requirements for veterans benefits. So you could use one of these types of trusts, have the assets in there for at least 3 years, and then apply for the veterans benefit to get that aid and attendance benefit. It can also be helpful with, protecting assets from the nursing home and accelerating eligibility for Medicaid. But you would have to have the assets in the trust for at least 5 years before you would be applying for Medicaid for this type of trust to work. So some of you may have heard of that before. We call it the 5-year look back. So that's what is meant by that. Because when someone is out of money and they apply for Medicaid, or in Pennsylvania we call it medical assistance, then the medical assistance group, when you apply, is going to ask for 5 years of tax returns, bank statements, investment accounts, because they want to see if you made any big transfers in that last 5-year period. So you do have to transfer into the trust before that 5-year period. It would also provide some creditor protection. So if you have a loved one who keeps getting scammed or has a lot of credit card debt, whatever it might be, and maybe they're going to get an inheritance or something, and you don't want them to have it all taken away or garnished, this is something that could be helpful with that as well. So the Secure Act happened in 2020, and then they did like a Secure Act 2.0 shortly after that because the Secure Act was just so confusing for people. I thought I would mention it here today because it does have to do with, inheriting assets and what happens after someone passes away and they had an IRA, for example. So it used to be that if someone passed away and they had an IRA or a 401k, one of those retirement accounts, the beneficiaries could take the account and inherit it over the beneficiary's life expectancy. But now the Secure Act has changed that so that it has to be taken out over 10 years, and they have to take a distribution each year over that 10-year period. And then the account must be exhausted at the end of the 10 years. Now, there are some people who are exceptions to the 10-year rule. A surviving spouse would be one, a child under 21. But then once they reach 21, they are going to only have the 10 years to empty it. Anyone who's not more than 10 years younger than the person who passed away, an individual who is chronically ill, or a beneficiary who has a disability. So like say they're getting Social Security disability, then all those individuals can take it out over their life expectancy instead of, having to follow that 10-year rule. So just something to add on that and keep in mind, as we talked about the Pennsylvania inheritance tax, if you're leaving someone an IRA, they're going to get hit with the inheritance tax, assuming it's somebody who's a taxable person, so like a child who's over 21, and they will also have to pay income tax on their distributions from the IRA. So the IRAs are going to be double taxed. So just want to make sure that you understand that and keep that in mind. I've seen some people start to strategize with that because they are at a lower income tax rate, say, than their children are. So they might start taking out more money from the IRA and just paying the income tax now so that ultimately there's less income tax paid. I will caution you, though, you definitely want to speak to an accountant before you do that because you want to make sure that you're not pushing yourself up into another tax bracket with taking this additional income. And you want to make sure that you're not increasing your Medicare premiums because those are based off of income and they really do add quite the fee once your income has surpassed their, minimal levels, and they'll keep it on for 2 years. So you really need to watch all that and look at your whole picture. All right. So that was all I had. Got done a little quicker than we might have thought, but were there any questions? You can check the chat here.
Yeah, feel free to use the chat, or if you have any questions, you can unmute yourself as well.
And that's my contact information up on the screen. So if you're not comfortable asking a question in front of the group, you can always shoot me an email and I'd be happy to answer it for you.
I have one.
Okay.
Wonder if you have a will made and you are an executor of another will and you die before the other person. Do you have to go all through this again, or can you just change the name of the person as your executor since you are no longer existing in the world? Like if you die and you are named as an executor, how does that work?
Yeah, so typically, like when I prepare a will, I always name backups.
Okay.
So if I have, first person named and that person has now passed, but I had two other people as my backups, I don't necessarily have to update my will because of that one person passing because I had the backups on there.
Okay.
Oh, okay. Let's see one in the chat here.
Mhm.
Can you incorporate healthcare POA in with regular POA? So that used to be very common that it was all in one general power of attorney that, tried to cover both sides of things. But like I said, probably in the last 10 years or so, there's been a real trend to separate those out because both documents have gotten so kind of complicated with all the provisions and things that are needed. And it's a much more comprehensive document when you have the two separated. It also makes sense because, like, let's say you're at the hospital and they ask you for your healthcare, POA. You don't really want to hand them all the financial legal stuff too. You just want to kind of give them the medical side. So that way it makes a lot more sense to have the healthcare POA in with your living will and have the financial POA be its own separate thing now. Is there a way to avoid taxes when gifting personal items like art and musical instruments? So when you pass away, if you own, personal items, like you said, like art, musical instruments, and your will says they're going to so and so, that's going to all be put on the inheritance tax return. You would have to give the items away more than 1 year before your passing to avoid the inheritance tax. So it's a 1 year clawback for that. And then how do you pay for burial? So you would contact whichever funeral home or cremation society, whatever one you want to go with, to work on that specifically with them. And then they would have a contract and everything for you. You do need to make sure, though, that you're not writing a check out to the specific funeral home, but instead they should be putting it in a burial insurance policy. So that way, if something happens to that funeral home, you can take it and use it at another funeral home. There was a big problem years ago where people were prepaying for their funerals, and then the funeral home would go out of business, and then the people would not get their funerals. So that's why I'm saying you definitely want to make sure that it is either in an irrevocable burial account at the bank, which is a special type of account there, or through a burial insurance policy. All right. Where can I access the most recent updated forms? So I would suggest that you talk to an attorney about that. And I think you probably knew I was going to say that. You have to be really, really careful, especially with Pennsylvania, because we have specific forms suited to Pennsylvania. And I have seen some people bring in online forms and they're just a mess and they don't work here. So you just need to be really, really careful and make sure that you're working with the right person who understands these things. Can I get this recording? I think that, Clayton, I'll let you answer that one. I think, don't you post it on the website or something?
Yes, a link to this recording will be emailed to everyone who registered, and it will also be uploaded to our PASR YouTube. And a link to those recordings are also on our website under the educational Zooms page.
Yeah. Okay, great. This person's asking what are the benefits of the revocable trust? So the revocable trust, I think I just went past it. Give me. So those benefits are actually, we have some here, like you can add or remove, you can change the beneficiary, so you can revoke at any time. And then all of these things listed here apply to both the revocable and the irrevocable. So, privacy, avoiding probate, setting up specific things for a beneficiary. But like I said, since the federal estate tax exemption is so high now, these trusts are not as popular because probate's not so awful here. Where is the best place to find information for another state if you were living in two states? So you would want to check with the state that has you as the domicile. So whatever is your primary residence, your domicile, for filing taxes and everything is the one that you'd want to check in with, because that's the one that's going to control when you pass away. What are ramifications if you have a trust but are at a nonprofit retirement community, which also provides life care if needed, similar to Messiah Village, Masonic Village, etc.? Okay. So it depends on the community. There are some communities, not one of the ones you mentioned, but some that in their contract it says that they do not want someone to have an irrevocable trust. And if they do, they want them to basically like sign it over to them. Now, depending on your assets, some people are able to use a trust and still be eligible for those places. I will say that usually those places have pretty high entrance fees and monthly fees on top of it. So they want to see someone who, has enough money to keep paying. So in some cases, you don't want to shelter your assets, say, in an irrevocable trust because you want to be able to get into, one of those places that might be like your dream community. Can you provide any specifics or examples to avoiding PA tax in a living trust? You only said living trust may help. Yeah, so it would be an irrevocable trust. You would have to have the assets in there for at least 1 year before you would pass. And it has to have very specific provisions to avoid the tax. It cannot be just that it's irrevocable. Like you can't benefit from it at all. You can't have any control over it. And even then, they're trying to go after some of them. So it really depends on the situation. And then there's one more. Oh, in order to set up PODs, which are pay on death, such as with a bank, what procedures should you follow? So typically you can work with the financial institution on that, and then they have forms and things that you can do with them. But that would be with the actual financial institution. Are 401k IRA funds for a spouse required to be spent down prior to applying for Medicaid for the other spouse? So when we're dealing with Medicaid and applying for, so let's say we have spouse A and spouse B, okay? So let's say spouse A needs Medicaid and is in the nursing home. Spouse B's 401k IRA will be completely protected from spouse A's care. But spouse A's 401k and IRA would be fair game. All right, great questions. Any other questions or concerns?
I have a question for you.
Okay.
Our we own our daughter's house, and she is currently paying rent. And the question is, we willed it directly to her when we die. Is it best for her to buy it now and put it in her own name, or is it best for her to continue to pay rent?
So I would need a little more information, and probably not information that you would want to share in front of the group. So I would suggest that you contact me directly and we can have a separate phone call to talk about
Okay,
it.
no problem. That's
Okay.
fine. Thanks.
All right. Any other questions or concerns?
So how do we contact you?
Oh, I'm sorry. I put that screen away. Let me get you there.
Here.
Yep. So my email is there, and
Okay.
then also my phone number.